Thank you, counsel. We appreciate your flexibility. This time we're going to call State versus Connor, and we'll hear from the appellant.
Mr. Chief Justice, Associate Justices, and may it please the court. Pardon me. My name is David Andrews. I work at the Office of the Appellate Defender, and I represent Riley Connor. I'd like to reserve 5 minutes. I ask this court to reverse the opinion below. This case, like the others, is about how courts should handle sentencing for juveniles convicted of serious crimes and that judges believe are redeemable. In Miller v. Alabama, the Supreme Court set forth a substantive standard that even if a judge considers a child's age before imposing life without parole, that sentence still violates the Eighth Amendment for a child whose crime reflects transient immaturity. That substantive standard was discussed in Montgomery v. Louisiana and then by this court in State v. James. It was referenced most recently in footnote 2 in Jones v. Mississippi, in which the court discussed what it described as the key paragraph in Montgomery. That key paragraph reiterated that although Miller did not impose a formal fact-finding requirement, states are not free to sentence a child whose crime reflects transient immaturity to life without parole. What we have here with Riley is a judgment in which the trial judge imposed life with parole and thereby determined that Riley should have a chance at release, that he could be rehabilitated, and indeed that he was redeemable. And so the question for this court becomes, what constitutes a life without parole sentence? Can decades in prison before parole eligibility qualify as the functional equivalent of life without parole? The answer is yes. Graham v. Florida speaks to this issue because it gives contours to what life without parole really means. You can't read Graham and come away thinking that life without parole only means literal or official life without parole. Graham talks about how life without parole deprives children of hope of restoration, of the chance not only of living outside prison walls, but fulfillment outside prison walls. It deprives them of the chance for reconciliation with society, of finding one's value and place in society. Montgomery adds to this, if a child is not irreparably corrupt, that child must have hope for quote unquote some years of life outside prison. These aren't empty words. Life without parole is not a label. It's the effect that matters.
I don't like interrupting you early, but you said just a short time ago,
yes,
so that's why I want to go ahead and bring it up while it still may be fresh on your mind. You just mentioned the prospect of a juvenile having a, quote, chance of release, unquote. If there is indeed, as in this case, you've got here a juvenile who got a sentence for rape as well as a consecutive sentence of life with parole, which would have him at a prospect of after 45 years potentially being released at age 60.
Correct.
If I recall the record
That's
correctly.
Correct.
Is that a chance at release?
That chance comes too late, Your Honor. And I want to speak to this because the concerns I just talked about in Graham relate to this point. That chance comes at a time when Riley will be 60 years old, and it's also not guaranteed that he will get out. You know, even if you all rule for Riley, you're not opening the prison gates for him at age 60. But by age 60 for him, a huge swath of life will be over. You know, and it's not just a chance, it's a meaningful chance, okay? And so while others will be starting to retire, if he gets out in his 60s, he will be starting from scratch. And he will not only have spent his entire adult life in prison, he will have grown up in prison. He's growing up in prison right now. Think of his support system, okay? Getting out in your 60s, his parents will likely have died. Any friendships he had will have frayed. imagine, for example, a 15-year-old defendant sentenced to 45 years in prison, getting out in 2021, okay? That 15-year-old would have gone into prison in 1976. Can that person really navigate the world at that age? It's almost too late. It is too late. Now, I want to bring something out from the amicus brief filed by the North Carolina Advocates for Justice.
Counsel, before you get there, in Graham, the Supreme Court stated that a state is not required to guarantee eventual freedom to a juvenile offender. Are you asking for an expansion of Graham?
No, I'm asking really, this is about Miller and Graham, okay? Miller talks about how redeemable children cannot be sentenced to life without parole. And the problem here is this sentence is the functional equivalent of life without parole, okay? The other thing about we're not asking this court to expand Graham is to remember what the Supreme Court said in Miller about Graham, okay? They say, and I'm just going to quote here because it's important, it comes to this point. This is from page 473 of the U.S. Reporter in Miller. To be sure, Graham's flat ban on life without parole applied only to non-homicide crimes, and the court took care to distinguish that from murder. But none of what it said about children, about their distinctive traits and environmental vulnerabilities, is crime-specific. Graham's reasoning implicates any life without parole sentence. The problem here is that a trial judge found that Riley was redeemable and yet imposed a type of sentence that is the functional equivalent of life without parole.
But in order to implement is on the word that's on the tip of my tongue. I don't know that it's exactly the right one. But in order to give meaning to what you're asking us to do and what Ms. Vandenberg was asking us to do earlier, we have to have some way to identify what is a de facto life without parole sentence. And in order to do that, it requires some determination to be made as to what is the maximum point at which a person is entitled to be eligible for parole.
Correct.
How do we do that? I mean, there's no statute that says that. There's no case that really defines it as far as I can see. What's a court? You know, we have to, in order to give this right that you're advocating for constitutional meaning, we have to know what we're doing. How do we do what you're asking us to do?
There's been some discussion that there's, no constitutional guidance here. There is guidance, and it's...
There's some language, but it's pretty broad, general language, and we would have to decide, either you'd have to say, adopt some standard, which almost by definition is going to be arbitrary, or you've got to tell somebody how to do something. We've got to figure out some way to apply this, otherwise it's, it's sort of just evanescent.
Totally understand where you're coming from. I appreciate it. I would ask that you start with the parts of Graham that I quoted, that you start there. Those are general principles, I understand. I submitted in a memorandum of additional authority a case called Commonwealth v. Brown out of Massachusetts. And that's a case where an appellate court struggled with a question like this from the Supreme Judicial Court of Massachusetts. And what happened in Brown is the Supreme Court found that life without parole was unconstitutional for juveniles, or for the juvenile in that case. And after making that threshold decision, they had to come up with a remedy, okay? Where do you draw the line? They employed, doctrine.
I mean, is it just a remedy, or is it part of the definition of the right?
Well,
because it seems to me that if you're going to decide that some particular sentence or combination of sentences results in de facto life without parole, you've got to identify at what point that sentence or those sentences reaches the point of being de facto life without parole. So I'm not sure it's not part of the right itself as you advocated it.
This comes back to Graham, that it's got to give hope for fulfillment outside prison walls, hope for reconciliation with society. It's not just walking out of prison and dying a few days later. It's more than that. Graham provides constitutional guidance on this question, but I do, what happened in Brown is not unlike what Chief Judge McGee was doing in her dissent in this case. She's casting about for an answer, kind of like what you're asking. She doesn't draw a number out of a hat. She chooses a statute that's the most relevant statute, the Miller fixed statute. And she notes that for juveniles convicted of first-degree murder, the General Assembly found life with parole after 25 years to be acceptable. That at the very least, our legislature believed they arrived at a number that to them was acceptable for juveniles convicted of first-degree murder. In addition, the other benefit of that, if you're thinking of ways to craft a solution, that floor at 25 years, it has a benefit. It gives judges guidance. It is a bright line rule. It is easy to follow. There's not confusion. And then thirdly, this 25-year rule, it addresses the concerns that I talked about lengthy sentences. It gives redeemable children a real chance to be redeemed. They get to prove themselves to the parole commission, the body that really can decide whether redeemable children have proven themselves and are worthy of release at a later date. There was a lot of talk about Jones v. Mississippi, and I'd like to make a very specific. Did you have a question?
Let me ask you a question. Justice Berger raised the issue this morning of whether acceptance of your argument amounted to giving a criminally volume discount, I think was his word.
Right.
Which, it does seem to say in effect that no matter how many crimes you commit or what severity they may be, your parole eligibility date is the same. However you choose to categorize it, what would be your response to that kind of counter-argument to what you're urging us to do?
Well, I have a few responses to that specific argument. I don't think a pound-for-pound approach is appropriate with children, okay? I think that elevates retribution over other concerns when it should be the other way around. It's really the rehabilitative ideal that is central to Graham and Miller. But another thing that I would ask this court to think about when you're thinking...
Where do we, are we constitutionally required to, given the, you've mentioned rehabilitation, you've mentioned retribution, there's some others that are generally considered to be components of a legitimate penal system. Is it your contention that rehabilitation has to be elevated above the others as the result of Graham, Miller, and other decisions?
That is definitely a more important concern for the Supreme Court in Roper, Graham, and Miller, rehabilitation over retribution. They talk about in Montgomery how the penological justifications for harsh sentences collapse in light of the distinctive attributes for youth. But back to this question about volume discounts, I want to just say we have this authority for judges under 15A 1354. They can run sentences concurrently, consecutively. They can consolidate them. But just remember, that authority, that statutory authority to run sentences with multiple victims, either concurrently or to consolidate them, acknowledges that you can still vindicate victims by running those sentences concurrently. You don't always have to run them consecutively. There's not a meter running, okay? And furthermore, if Riley, or whoever the juvenile is not redeemable, he will be serving more time in prison, okay, if he doesn't get out on parole. I do want to get to Jones v. Mississippi. There's a point that came up this morning toward the end of the majority opinion in Jones. The Supreme Court takes a moment to remind everyone that states can go their own way. They are empowered to impose their own procedures or limitations at Miller sentencing hearings. That part of the opinion, I believe it was Justice Earls who talked about, there was a list of things that the Supreme Court said states can do. At the end of that list, they cite this source that I had never heard of, and I overlooked it, frankly, for a while. This book called 51 Imperfect Solutions. I looked it up, because I'm a nerd, and I commend it to you. It's written by Jeffrey Sutton. He's a federal judge, and he has something important to say here for this court about the practice of lockstepping, okay? The practice where state appellate courts tie their state constitutional protections directly to what the U.S. Supreme Court says about federal protections. And he says The practice of lockstepping is a grave threat to independent state constitutions. It's a key impediment to the role of state courts. He even says there's no reason that constitutional protections involving the same or similar wording have to be construed the same way. Now, I think the U.S. Supreme Court would agree with me here that they don't have a monopoly on what constitutional protections mean, especially with state constitutional protections. And so my point is, if for whatever reason, hypothetically of course, you don't find that this sentence for Riley violates the Eighth Amendment, that shouldn't hold you back on the state constitution. It is different. It's different language. There is a difference between the conjunctive and the disjunctive or, and I want to give this court an example. The Florida Constitution used to say that it barred cruel or unusual punishment. They amended that in 1998, and it now bars cruel and unusual punishment. If these really were the same, that whole amendment process was unnecessary. But they are different. That word or means something. And so you can and should find that the sentence here violates Article 1, Section 27 of our state constitution. You're stewards of this state charter of ours. It's ours. We get to say what it means for our citizens, and in this case, for one of our children. It really is a disservice not to apply an independent analysis to this constitutional protection. And there is good reason to find greater protections here.
You don't disagree that the constitutions of the original 13 states certainly impacted the drafting and adoption of the Eighth Amendment?
I don't disagree.
And in interpreting what was intended in our state constitution, we certainly should look at the circumstances surrounding cruel and unusual punishment at the time that it was originally enacted, correct?
I don't know if I agree with originalism. I mean, it is an important tool at times, but also our Constitution was adopted most recently in 1971, right? And so don't we have to think about what people, if you're agreeing with originalism, don't we have to think about what everyone was understanding in 1971?
Well, but that would go to the point of how have we historically interpreted this provision in our state constitution with the vis-a-vis the Eighth Amendment.
Okay.
And if we have historically said that our jurisprudence for the Eighth Amendment or for cruel or and unusual punishment is consistent with the interpretation of the Eighth Amendment, then that certainly would have bearing.
You know, it's a curious phraseology in Green. We have historically analyzed the two protections the same. Just because you've historically done so doesn't mean you have to continue to do so. And there's also that footnote that
But meaning, is there any meaning, or it only means what we think today it ought to mean?
under the Eighth Amendment, if you're looking at the Eighth Amendment, we do work under evolving standards of decency, if that's what you're getting at. But ultimately, there is a difference between cruel and unusual, cruel or unusual, and it's a separate document. It's our own Constitution. The wording is different. Footnote 1 in green, you can find greater protection for a compelling reason. These cases involve children. We devote so many resources to children. School, juvenile court, mental health court for kids, child welfare. If that means anything to our law, it means that we don't throw children away, and that's relevant here for Riley with sentencing. I do want to take a few minutes to remind everyone about Riley's circumstances. In Graham, the Supreme Court reminded us that U.S. Supreme Court case law underscores the essential principle that under the Eighth Amendment, the state must respect the human attributes, even of those who have committed serious crimes. What they're saying is, don't forget the individual at the center of the case. Riley had a tough childhood. Ms. Blagrove talked about how it takes a village to raise a kid, and that Daryl's village failed him. Riley's village certainly failed him. At the center of his life was neglect. You know, his parents struggled with drug addiction. They sold his Christmas presents to buy drugs. When Riley's sister was born, his dad was supposed to pick them up from the hospital. What did he do instead? He robbed a convenience store. All Riley wanted was his mother's affection, and he couldn't get it. He had damage to his frontal lobe, epilepsy, rampant drug abuse, no structure, chronic instability. You can look through Riley's life through the prism of adverse childhood experiences and spot several: physical neglect, emotional neglect, household substance abuse, a family member incarcerated. Poverty certainly plays a role, but at the end of the day, the trial judge agreed that there really were traumas here. The trial judge found, for example, that Riley exhibited numerous signs of developmental immaturity, that he was passed from one family member to another, that his parents were absent for the vast majority of his life, but nevertheless, in juvenile detention, Riley showed some maturity and was worthy of parole eligibility. The problem, though, is that parole eligibility under the current structure of those sentences comes too late to be meaningful for Riley. It is almost unattainable for him. Riley is also a stand-in for these juvenile defendants that you have seen and you will see in Miller cases. He represents all these things that the Supreme Court talked about in Roper v. Simmons. Dependency, this idea that you don't get to choose the family that you're born into. Riley didn't get to choose parents who suffered from drug addiction. This other aspect, the negative influence of peers. This is another reason that in Roper, the U.S. Supreme Court banned the death penalty for kids. His older cousin, Brad Adams, was a terrible influence, and just in a crazy plot twist in this story, the day before Riley was sentenced, his cousin, Brad Adams, was arrested for a string of crimes. He was flying out of South Carolina and he must have crashed into several patrol cars here in North Carolina, and he's charged with a string of crimes. Brad Adams was a terrible influence on Riley. And then thirdly, we're back to this capacity for reform. Riley showed an ability. He demonstrated that he could be redeemed, and it's important to give him a real chance to actually be redeemed. Running a little low on time, so I'll start to conclude unless there are other questions.
Well, I would just like to ask a question. I'm sorry, but to go back to this issue of if we recognize that there are de facto juvenile life without parole sentences, where do we draw the line? And you started to talk to us about a decision from Massachusetts, but isn't it true that other states have undertaken this enterprise and determined what a reasonable line to draw is for when you have a de facto juvenile life without parole?
They certainly have. The state of Connecticut, or the Supreme Court of Connecticut in Cassiano, the Supreme Court of New Jersey in State v. Zuber, Wyoming in Bear Cloud, which found 45 years to be a de facto life sentence, by the way. Other states have. They have found Iowa is a classic example of a Supreme Court that finds greater protections under their state constitution, and specifically with de facto sentences in a case called State v. Null. In conclusion, I just want to share a brief story. Back in 2016, I went to a meeting of the Commission on the Administration of Law and Justice, specifically a subcommittee meeting for the question of raise the age. I was still learning my way around the juvenile code, and so I went just to soak up what I could learn. And there was one district court judge who was explaining to all the stakeholders why it's so important to raise the age for North Carolina. There are a lot of reasons, but one of them hadn't occurred to me, and it stuck with me. If we hadn't raised the age of juvenile court jurisdiction, we, the adults in the room, in the only state at that time still not raising the age, would have continued to actively harm our kids. We would have saddled 16 and 17-year-olds with felony convictions where 16 and 17-year-olds in other states, aren't sent to Superior Court. And so his point was, this is like a competitive disadvantage for our kids, but it's also morally wrong. Every other state protects their kids, we should too. That reason, among many other reasons, won the day, but it's applicable here. This court has a chance to find protection for kids. It should protect kids like Riley, even at sentencing in a case like this. And I ask this court to reverse the opinion below to find that the sentence here violates both the Eighth Amendment and the North Carolina Constitution.
Counselor, before you,
Yes.
if I may, would you please clarify, raise the age in North Carolina, was that a legislative matter or was that a court matter?
It was legislative,
Thank
but
you. Thank you.
okay. Thank you. I'll save my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good afternoon, Your Honors. May it please the court. Again, my name is Kimberly Callahan, and I represent the state in this matter. In the days leading up to the murder of Miss Felicia Porter, defendant threatened to make her pay when she called a 911 operator and stated that he needed to be locked up after juvenile petitions were taken out on him for unrelated crimes. On the morning of March 11th, 2016, defendant walked down to her house while her husband was gone, dragged her outside, forcibly raped her, and then beat her to death with a shovel. Ms. Porter sustained numerous severe and traumatic injuries during these attacks. The defendant then walked away and casually had a conversation with a neighbor down the road. It is undisputed that during the sentencing, the trial court properly considered defendant's evidence of mitigating factors, such as his traumatic childhood, his drug abuse, and his medical issues, and credited that evidence, as well as considered the circumstances of these offenses that he committed prior to imposing any sentence. Again, the very narrow question of law that is presented in this appeal is whether the trial court was constitutionally permitted to hold defendant accountable for both of his terrible crimes by imposing consecutive sentences of life with parole for first-degree murder and a term of years for first-degree forcible rape. Again, the answer to that question must be yes. The defendant here received the type of individual sentencing that the Eighth Amendment and Miller and its progeny demand, and the Court of Appeals majority should be affirmed. The defendant's argument here rests on the erroneous premise that life without parole or its functional equivalent is unconstitutional whenever a juvenile who has committed the murder is found to be redeemable. This is now a rejected view of Miller and its progeny per Jones versus Mississippi. Life without parole has never been categorically prohibited for any juveniles. And how do we know that? Because Miller explicitly states that, and it's reaffirmed in Jones versus Mississippi. What is required under the Eighth Amendment is a discretionary sentencing scheme where youth and its attendant circumstances is considered prior to imposing any sentence on a juvenile offender, and it demands nothing more.
Counsel, just so I can be clear.
Yes, Your Honor.
You would agree that under Miller and Montgomery, there are some circumstances in which a life without parole or a de facto life without parole sentence would be unconstitutional?
Certainly, Your Honor, yes. Yes, I would not dispute that. The trial court made findings of fact and conclusions of law and determined that life without parole, based on the mitigating evidence that was supported, was not the appropriate punishment here. But with that being said, that does not mean that the trial court was not allowed to also punish the defendant in this case for both of his crimes. Now, the defendant argues that the proper starting point for understanding why his 45-year minimum sentence is the functional equivalent of de facto life without parole. But if you look at Graham, other than for the purposes that youth matters in sentencing, it has absolutely no applicability to the question that is before this court. And it expressly states that sentencing practices for juveniles who commit non-homicide offenses is materially distinguishable from when a judge or a trial court has an offender who has committed homicide offenses or homicide offenses and non-homicide offenses. So Graham's applicability is or its rationale, other than youth matters, is just simply not, it doesn't lend any support to the Court of Appeals decision, doesn't support the dissent in this case. Again, the majority in this case found that Miller has never held, and none of the prevailing Eighth Amendment jurisprudence has held, that life with parole sentences are unconstitutional. And that reasoning should be upheld here too. We've talked at length about the problems that come with trying to demarcate that line. Where is that line? And the Court of Appeals dissent in this case says, well, it's got to be 25 years for juvenile offenders, regardless of the circumstances of their offense or the number of the offenses that have occurred. But I would suggest to this court that that blanket rule of 25 years actually offends the Eighth Amendment and the jurisprudence that comes down from Miller. Miller invalidated mandatory sentences because they treat all individuals the same, and the Court of Appeals dissent in this case does just that. You can't take it, there's no sentencing discretion. Doesn't matter the nature of the offenses, the number of offenses. All that matters is that the juvenile was under the age of 18 when he committed his offenses. And justice requires, and our Eighth Amendment jurisprudence requires, that both the nature of the offenses and the offender be considered, and that was what was done here. Again, I would argue that the defendant's arguments, considering the breadth of the North Carolina Constitution, are not properly before this court. His argument was not adopted by the dissenting opinion in this case, and is not properly before you now. But with that being said, this court in Green, in a footnote, explicitly rejected the notion that the difference in the text between our Constitution and the federal Constitution gave broader protection to juveniles. There was some concurrence in another decision that suggested that that could be the case, and the court specifically stated, we see no reason to adopt this position. And there's, historically, these provisions have always been read the same and in parallel, and there's been no real compelling reason to use the state constitution in this case, other than the defendant simply is looking for a way to kind of circumvent the legislature's function, because there's no Eighth Amendment violation here. So, yes, the state can make changes, but the appropriate vehicle and all of the policy issues that have been argued today should be argued to the legislature for legislative change. I see I have a lot of minutes left, so I would like to take this opportunity to answer any other questions. I know we've talked about this for quite some time, and I don't want to waste time making the points that I've already made previously, but I will be happy to address any lingering questions that you may have for me. Then the state would respectfully request that the majority be affirmed in this case. Thank you.
Thank you, counsel. Rebuttal.
May it please the court. The state constitutional argument is properly before this court. It's up here on a silver platter. It was raised and ruled on in Superior Court. It was raised in the Court of Appeals and ruled on in the dissent, and it's raised here. State v. Bullock, which the state relies on to say it's not, is distinguishable. The claim that this court rejected was not at all considered by the dissent in State v. Bullock. It was considered in this case. It is absolutely before this court. If you need a roadmap for a state constitutional protection like ours, look at People v. Bullock out of the state of Michigan. It's mentioned in the Kelleher briefing, but it's also in the North Carolina Advocates for Justice briefing. They say in Bullock that even a difference in wording can provide a compelling reason for providing greater protection. But we have compelling reasons here beyond just the wording. This case involves kids. It is cruel to sentence redeemable children to die in prison, or the functional equivalent of that result. In addition, we've come a long way since State v. Green. Again, footnote 1, you said you can find greater protection for a compelling reason. Times are totally different now. In 90s, if you read the majority opinion, fear was going on. There was a real fear of crime and juvenile crime. This court cited lowering the age of transfer as a reason to uphold the sentence. We've gone in the complete opposite direction. Obviously, we talked about raise the age. We've done that. We've also raised the age that kids get additional protection during custodial interrogation. Just the other day, the General Assembly passed another law providing greater protections under raise the age. Prosecutors have more discretion to keep low-level felonies in juvenile court. There are compelling reasons to find greater protection here. This other point that the state has made about how this idea of redeemability is no longer the law under Miller, that there's this bar against imposing life without parole for redeemable kids. That is alive and well. It most assuredly is. The Supreme Court, we know this because the Supreme Court said so directly, explicitly. They said, we are not overturning Miller and Montgomery. Montgomery says over and over and over again, redeemable children cannot get life without parole. Remember, when you're looking at Jones v. Mississippi, that is a procedural case. That case is only about the procedural component. It's not about this separate part about the substantive right at issue in Miller sentencing cases. Graham is also, a separate point, about more than just youth matters at sentencing. It's more than that. At a very minimum, it's about how you can't impose life without parole for non-homicide convictions. Miller talks about how it's more than just youth matters. They say that Graham also stands for the proposition that juveniles are constitutionally different from adults for purposes of sentencing. Miller also says that Graham emphasizes that the distinctive attributes of youth diminish the penological justifications for imposing the harshest sentences on juvenile offenders. This sentence is too long to give Riley hope for fulfillment outside prison walls, to reconcile with his community, to make a life. And so I ask this court to reverse the opinion below, find that this sentence is too long. Thank you.
Thank you, counsel. Thank you to both counsel.